It's funny how the mainstream media is just blatantly ignoring this actual fact of the case. Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Ray's affidavits. 2. We went over them in a live on Friday night. The link for that one will be down in the description box if you want to go over and watch my true reaction and see the interaction between me and the guys in chat. What I want to do here in this video is make it a little bit shorter, to the point, more concentrated, so that people understand why this is a big deal. Now, one of the first things that we find out is that Ray actually was asked by the FBI back in 2021 to look over a set of AT&T timing advanced records, further proving that the state is not being truthful whenever they try to claim that this type of information just wasn't available. Something else he told us was that the GLDC, the company that works with AT&T called the Global Legal Demand Center, is not the only way to obtain these records. He calls out somebody by name specifically, a Mr. Boyd Jackson. This is somebody that Ray claims that he has personal knowledge of their involvement in obtaining these types of records with AT&T. And according to him, he's the primary contact that the feds go to with AT&T when they need records like this. When it comes to the actual timing advanced records, we've been being told that AT&T, GLDC are the ones who actually obtained the information or helped work on the information. That's how it's sort of been portrayed to us, especially whenever we go in and we see records in the self-authenticating records list where there are documents from employees with GLDC signed and attached to the court doc. What Ray is claiming is that GLDC is not the one who did this, because they didn't actually start doing this type of work for AT&T until after the time of the crime, meaning that AT&T was utilizing a completely different company back in 2022 for this kind of record keeping. I'm going to go ahead and read this part of the document to you, because this is where we find out that one of the lead suspects, one of the main suspects that first came about, was actually part of this tower dump that they mentioned here. During this investigation, law enforcement obtained the following AT&T timing advanced data. 2 of the victims had AT&T phones. Law enforcement obtained AT&T timing data on both of their phones. The information that we actually got from the self-authentication list is that it was Maddie and Xana who also had AT&T. AT&T phone records for Bryan Kohberger, Maddie, and Xana handed to the defense on April 5th, 2023 via a hard drive. The above AT&T phone records are relied upon by the state's expert witness, Nicholas Balance, has detailed in his expert disclosures. A certificate of authenticity is attached as Exhibit S3, which was included with the return for Bryan Kohberger's AT&T records for November 12th through the 14th of 2022. This was provided to the defendant around April 4th of 2023. This is also a list from the state, just so you guys are aware. A certificate of authenticity is attached as Exhibit S4, which was included with the return for Bryan Kohberger's AT&T records for June 23rd of 22 to December 23rd of 2022. This was provided to defendant around April 4th of 2023. Call detail records were provided for both Maddie and Xana, discoverable on 2 different dates, on May 16th and April 16th, both in 2024, and the state intends to obtain a certificate of authenticity from AT&T that goes with the rules for this. So they have what they're claiming to be certificates of authenticity for 2 different sets of information from AT&T for Bryan Kohberger, but when it comes for the records for Maddie and Kaylee, they're still working on getting those this far into the case. Why? Now, this is the first certificate of authenticity when it comes to AT&T and GLDC that we have in this, and as always, the link for this document will be down in the description box. Now, this is written and signed by Mike Figueroa, attesting to the authenticity of these records, and it's from and dated on 12/23 of 22. Now, we know that this is most likely from the very first warrant that Brett Payne actually drafted for Bryan Kohberger. He told us that the very first one for Bryan ever was the one for AT&T. He said that on the stand. Now we have another one by a Stephen Gordon claiming that AT&T provided records for the phone number 509-592-8458 responsive to the referenced search warrant dated December 23rd of 2023 for records between November 12th, 2022 at midnight and November 14th, 2022 at midnight related to the November 13th, 2022 homicides. AT&T did not provide timing advance records for phone number 509-592-8458. They're claiming right now AT&T did not give you this. Timing advance records were only available if requested within 7 days of the specified time frame. Impossible for them to have even obtained it from this company. And then it shows a copy of that search warrant. And if you go all the way down here, you'll see that it is dated 12/23. And then we have another one right here by a Gary Cohen. And this is just as blank as the Mike Figueroa guys was. And then under that, we have another one from Stephen Gordon. And now this one right here from Gary Cohen is 12/23 of 22. This one right here that we just went over is 3/24 of 25. And so is the new one. It's 3/24 of 25. So this information here was retrieved from AT&T December of 2022, as is the date. But then all of a sudden, just 2 days or so before they ended up actually filing this information, we now have these coming in. Now here they're showing the warrant in question, and this one is actually for the pin trap and trace device for Kohberger's phone. So GLDC has been being mentioned for a while now when it comes to location information and the possible exculpatory information that Bryan Kohberger has claimed from day one his phone was going to prove. What's interesting is that GLDC, again, did not even start storing any sort of information like this until May of 2023. That's why these documents are signed this year in 2025, and they're not for any of the victims' information, because that company that gave the feds and the state all of the victims' information for this was not GLDC. Those certificates of authenticity are going to be coming from a completely different entity. It then goes on to say that law enforcement developed an early investigative lead in this case. That person had an AT&T phone at the time of the crime. Law enforcement obtained his AT&T timing advance data. And again, that would not have been being obtained from GLDC. This is a really wild portion of this. The AT&T timing advance data was obtained by the FBI using an internal source at AT&T, Mr. Boyd Jackson, who is not associated with the GLDC working group. GLDC was not used to obtain this data. A forensic examination of the AT&T timing advance records in the state's possession show Mr. Jackson's association with the reports. There is work product in the state's possession created by the FBI showing the AT&T timing advance data was not only obtained, but regularly referenced and used in the course of this investigation. Its existence is well known to the investigators and the prosecutors. This is where he gets into the information about the chain of custody issue with the certificate of authenticities. The state has provided a certificate of authenticity to defense in relation to the timing advance records described above. The COA was created April of 2024 and issued by the director of GLDC, Stephen Gordon. We saw his name on the documents that we just went over. I have previously worked with and I am familiar with Mr. Gordon. The COA specifically states, I am qualified to authenticate the records attached hereto because I am familiar with how the records were created, managed, stored, and retrieved. I have personal knowledge that in the event Mr. Gordon was required to testify, he would clarify that prior to May of 2023, neither he nor the AT&T GLDC working group was involved with AT&T timing advanced records. Additionally, there is forensic evidence contained within the records that indicate they were not produced by AT&T GLDC, nor were they produced in the year of 2024. In reviewing this data, I contacted and communicated with Mr. Gordon to clarify the chain of custody related to these records. Mr. Gordon and an AT&T legal representee informed me that Mr. Gordon would not be the individual to certify these records if required to do so, despite being the one who issued the certificate of authenticity. Doesn't that sound just weird? In my review of this information, there is evidence to suggest the chain of custody involving these records and certificates of authenticity were produced well outside of AT&T's normal practice. There is missing information and data associated with this request. The prosecution's prior claims that AT&T timing advance data did not exist in 2022 further complicates this issue because it's a lie. It was just with a different company. It is my expert opinion that any testimony proffered on behalf of the FBI or AT&T in this matter would clearly reveal these issues. Now, here is where Ashley Jennings gets what she deserves for everything that she's caused in this case. She is a horrible attorney and needs to be taken completely off bar. She has no clue what she is doing. And Hippler knows that. That's why whenever she's out there talking, he's literally guiding her into the next statement because she has no freaking clue what she's doing. Evidence in direct contradiction of the state's motion. In my review of this investigation, I have read numerous emails sent and received by law enforcement pertaining to their investigation. One such email, dated 11/15 of 22, so 2 days after the crime occurred, was sent to prosecutor Ashley Jennings at her Latell County government email address. This email is from Moscow Detective Lawrence Mowry. The email is informing Ms. Jennings of Detective Mowry's recent contact with FBI Special Agent Balance. SA Balance informed Detective Mowry that AT&T can provide timing advance data and to make sure it is listed in the warrant. Detective Mowry is specifically asking Prosecutor Jennings to make sure that the AT&T timing data is listed in the warrant prior to the report ever even being distributed by the working group known as GLDC. Ms. Jennings did respond to Detective Mowry's email, inquiring on the specific verbiage needed to obtain that exact information. This email is abundantly clear evidence that Ms. Jennings was not only aware of the existence of the timing records in 2022, but also shows her intention to obtain it through a legal process from AT&T, meaning that for them to pretend like they don't have data when there should be data is a lie. Something else really interesting about these timing advance records is that it can actually tell if a phone was turned on or off. Now, you can do that with the forensic download of a phone as well. There's a way that you can go in and tell this a multitude of ways, honestly, from looking at the back end and internal details of a phone. But when it comes to the probable cause affidavit for arrest of Bryan Kohberger, it is just based off experience and knowledge that this phone was turned off. But that's not the truth. It really does seem like a phone call was actually made in that 7-minute period that is such a big, huge discussion right now when it comes to when his phone actually went off network. And what's disgusting is how Ashley Jennings acted about this. We saw this in the hearings in January. It's being brought back up again because of its relevancy. Let's just take another peek at how horrible of an attorney she actually is and how completely clueless she is.
Good afternoon, Your Honor. As you're well aware, you have to make 2 separate inquiries for each of the claims that Ms. Taylor has brought before you. First, you have to decide today, has the defendant made a substantial, not just a preliminary showing, but a substantial preliminary showing that the affidavits, and in our case, we're referring to the Exhibit A's that were attached to each of the affidavits for probable cause, that they were the basis, which were the basis for multiple search warrant applications, that within those Exhibit A's, there were deliberate or recklessly false statements or omissions. Now, if you can answer yes to that, then and only then should we move on. And then ask the second question, does that even matter? Does that even matter?
Can you address the allegation that the cell phone data was, I guess, purposefully erroneous as to the time that the phone was no longer reporting, which then relates to the supposed position of travel?
Right. Well, I still, I don't know that I completely wrap my head around the defendant's logic in this.
I have to, so help me out.
Well, I still don't
I
understand.
understand her statement and her argument. I'm trying to understand your response.
I guess what was reported was the information known at the time that the probable cause affidavit was given.
By
There's-
Detective Payne? Or by the
With
cast
information
member?
that he was given from.
This goes to my first question about imputed erroneous statements. So I understand the allegation in that regard, not necessarily to be that Detective Payne knew the statement was wrong, because I'm not sure there's evidence of that. But did the cast specialist know that there was a misinterpretation or an erroneous report?
I don't think that you have before you a sufficient proffer that proves that the cast specialist submitted false information. Apparently, there's a difference in the handoffs of 7 minutes. At the end of the day, okay. No, I don't think it's incredibly material.
Is it material if you look at it in terms of where the phone was in that 7 minutes?
Well, it's material.
Going a direction different than what your affidavit says it was going, isn't that material?
The direction of travel, like, yes, I would say it was if it was found outside of Pullman. It was not. It was reporting to a tower in Pullman. It was reporting to a tower in Pullman. This assumption assumes that cars can't change direction of travel. We're assuming that then the same cell phone, which was then turned off, isn't then also tied to the evidence where we do have information to believe a white sedan tied to Mr. Kohberger is then found on surveillance. We're not talking about 7 minutes. We're talking about 7 minutes at 2:50 in the morning, which is about an hour, approximately a little over an hour before the crimes occurred. I don't follow the logic that this 7 minutes, an hour and 10 minutes prior, proves that there's no way the defendant couldn't have traveled the 7 miles to Moscow, whether or not the car was pointed in a different direction or not. It's a leap for me. Does that answer?
Well, it's your answer, so.
Let's say it was. Let's say that it was exculpatory. Let's say it was materially that it was false. It was recklessly included. It wasn't, but let's say it was. Well, the magistrate still had enough information before her to grant probable cause for the arrest. So we still don't get to a Franks hearing, even if you want to make that leap. We differ on a few factual issues. I believe there are 3 towers that provide service to the Moscow area. Defendant is correct.
Here's my concern with you telling me that at this stage of things. Where in the record is that currently? Apart from anything you may have submitted after they filed the Frank's motion,
What specifically?
that there are 3 towers.
I believe I referenced it in my response.
Well, yeah, but that doesn't, if you give me evidence and I rely on that evidence, then I have to give them a full Frank's hearing. And so that's why I'm been very clear to say I'm looking at what the proffer is from the defense without evidence submitted by the state to determine whether they have met their threshold burden. And so I get concerned when you start telling me things that are not necessarily part of the evidence.
Understood. We can move past the number of towers.
She has no idea which direction she's going next. The judge has to lead her. She says things that are not true. She's now claiming 3 towers, and the judge is like, hold up, there's nothing in evidence that says anything about 3 towers. What are you talking about? This is something that's been a big issue since January. Now, here we are almost in April, and this exact same scenario is coming around again with Jennings being inefficient and incorrect pretty much everywhere. Now, this is where Cyree is calling her out for being a liar. This email communication with Prosecutor Ashley Jennings is the same Prosecutor Ashley Jennings who filed this current and contradictory motion stating that AT&T did not produce the timing advance records in 2022. There is clear and convincing evidence that not only was the FBI able to obtain AT&T timing advance records in 2022, but that they did so with the knowledge of the prosecutors involved in the case. She knew that it was true that they actually did do this in 2022, but then decided to pretend like that wasn't actually the case. Why? Cyree goes on to state that it is his expert opinion that AT&T timing advance data did exist for the defendant's AT&T mobile device in 2022, and it was requested from AT&T by the investigators involved in the case. The investigators previously demonstrated their ability to obtain AT&T timing advance data in 2022. Failure to produce the defendant's AT&T timing advance data is either a gross deviation from standard practice or intentionally withheld from release in discovery. Now, that one was specifically about the AT&T timing advance records. This second affidavit that Cyree signed and put out as an exhibit by the defense is about S.A. Balance and his testimony. He's claiming right here that I have reviewed disclosures in reference to S.A. Balance's interpretations and opinions relating to AT&T call detail records. They are vague and at times contradictory. At this time, I am unable to identify his methodologies and or resulting opinions on most of his work, preventing me from any real analysis to determine the basis of his opinion. So once again, we're past the deadline, and the defense has been telling us for a few weeks now, over a month now, that when it comes to a lot of these expert witnesses, there's no opinions, there's no analysis, it's just some vague copy and paste paragraph that just keeps getting put into where their actual opinions and work on the case are actually supposed to be. The defense has nothing. They're not getting any information about what these experts are going to apparently talk about. And if the self-authenticating records list and all the stuff that got removed from that is any indication about how the expert witness list is going to go, I have a feeling the state's going to end up with really not a lot to fight with. It also goes on to say that the disclosures in reference to the facts and data relied on by S.A. Balances to form his opinions regarding AT&T call detail records are conflicting and void of substance. His work does not contain a methodology other than a paragraph. One paragraph. One. Wow. He does not mention AT&T, handoff data, drive test mapping, or any other critical methodology required in this analysis. The report does not provide explanation why SA Balance may or may not rely on AT&T data, preventing me from any real analysis of his opinion because, once again, we're past deadline. SA Balance and his information is on that exact same deadline because it's all going based off of the state's deadline timing, and it's not there. It's not there at all. We have a PowerPoint presentation that they're claiming to be the cast report, but it's just a draft. It's just labeled a draft. And again, the information on that report and what's in the probable cause affidavit for arrest, different timings. These are the things that he is claiming are missing from the Fed's reports. SA Balance did not include analysis of AT&T handoff data provided by AT&T for the defendant's mobile device on November 13th of 22 between the hours of 2:30 a.m. and 3 o'clock in the morning. That's the timing here in question, the 7-minute time issue. The one that Jennings thinks is just no big deal because it doesn't matter. That timing is in the probable cause order. So if the timing doesn't matter, why the frick is it in there to begin with? The handoff data in the defendant's AT&T records during this time is exculpatory to the defendant. SA Balance did not include an analysis of AT&T data regarding 23 time periods in his report that he appears to be suggesting the defendant was or was near the crime scene. There's no proof of it. This opinion appears to be based off of cell tower connections, primarily handoff connections, in the defendant's AT&T records, but it is difficult to determine the process or methodology SA Balance relied on to suggest this connection for several reasons because the AT&T records do not support the statement. There is no report or analysis detailing the defendant's movements between June 2022 and December of 2022, which would be needed to surmise the defendant's phone was at or near the crime scene 23 times prior to the homicides. So the information on that time frame of movement that they're trying to claim, that just from him moving there to right before the crimes, that he was there over a dozen times, now they're giving us a bigger date range from June of 22 to December of 22, and they're doubling the amount of times they claim that he was in the area, but they're not producing any proof. You know why they're not producing any proof? Because he can be sitting in his freaking living room, and because of the tower traffic, his phone go from a closer tower to a farther away tower and then back to a closer tower without him even having to move from his living room to his kitchen. Here's another conflicting statement where Cy has come out and said, I contacted these people. This statement is not true. This quotation is from SA Balance. The coverage maps are created using the actual measurements taken by the GAR and interpolation using the natural neighbor algorithm. In other words, it's looking at known values at known locations to determine the expected value at a location where a measurement couldn't have been taken. The natural neighbor algorithm was first published by Robin Simpson in 1981 and is widely accepted in both academia and as an industry standard in determining the coverage of a particular cell site within a broader cellular network. Cy says the following. This statement falls well short of any real disclosure of how the GAR product estimates cell site coverage areas. I have been in direct contact with Gladiator Forensics, and this statement contradicts what Gladiator Forensic communicated to me about their very own products. And I promise you, he's got proof of that conversation. Now, this next part's really important in my opinion, because just previous to this, I read to you that the 2:30 to 3 o'clock time frame is missing. That information is apparently just not there. And again, they made a big deal about it in the probable cause order for arrest of Kohberger. It says here, a recent disclosure states, page 13 depicts cellular phone usage by the 8458 phone on November 13th of 22, and Balance is expected to testify that when the 8458 phone interacted with the AT&T network at 2:47 and 29 seconds in the morning, that the phone was not at the Bryan Kohberger residence marked BK on the map. Rather, it was southeast of the Bryan Kohberger residence as depicted by the drive test data. Balance is also expected to testify that he analyzed additional handoff data that occurred during this data session, and that the 8458 phone stopped communicating with the network at 2:54, meaning to a lot of people, he was on a phone call and the phone call ended or he lost service in the middle of that call. This is why it's important. This disclosure does not provide an analysis or an opinion as to what SA Balance found when he analyzed the additional handoff data that occurred during this data session. This is the very data I previously testified having been omitted from SA Balance's work product and opinion. So the state is expecting Balance to get on the stand and testify to these things that there's no actual factual receipts for. And we're supposed to just be okay with that. Now, this is a document that actually came out in 2024, but it's important because it tells us that Cy has pretty much known about all of this since the very beginning, which is why I feel like even though his affidavits, again, in response to what's now been being given over and responded to and talked about by the state, even though some of this stuff might be past deadline, The actuality of it all isn't. All of it has been part of the case for a very, very long time. This is just information that we, the public, are now learning about, but we need to remember that Ann Taylor has been asking for correspondence, be it text calls, emails, memos, anything, when it comes to the prosecutors, the scientists, the detectives, anybody who's been touching this case. She's been wanting all of their correspondence. All of this stuff is already record. Again, the affidavit being written itself is the only thing that's really new here. But I wanted to show you guys this because, again, it goes to, this has all been stuff that we've known and that they've known and they've been talking about for a super long time. Mr. Kohberger moved to Pullman, Washington in June of 2022. As an avid runner and hiker, he explored many areas of the Palouse. Of note, he explored Wawaway Park in July of 2022, and this became a favorite location. After the school year began, Mr. Kohberger was busy with classes and work at Washington State University, and his running and hiking decreased but did not stop. Instead, his nighttime drives increased. This is supported by data from Mr. Kohberger's phone showing him in the countryside late at night and or into the early morning on several occasions. The phone data includes numerous photographs taken on several different late evenings and early mornings, including in November, depicting the night sky. A lot of people believe that this is where they're trying to state that he was out stargazing and he has photos on his phone to prove it. I mean, it's possible, but that's not actually what's being said right here. So the news people making it a big deal about, oh, stargazing, it's honestly really immature, dumb. Mr. Kohberger was out driving in the early morning hours of November 13th of 2022, as he often did to hike and run and or see the moon and stars. As he often did to do these things. Not claiming, oh yeah, he was stargazing, but then again, even if he was, so what? If he's innocent, who cares? Mr. Kohberger was out driving in the early morning hours of November 13th of 2022, as he often did to hike and run and or see the moon and stars. He drove throughout the area south of Pullman, Washington, and west of Moscow, Idaho, including Wawaway Park. Meaning they're telling you right now, he didn't go to Moscow. He was south and west and at that park area specifically. Partial corroboration. This is where the information about Cy has been brought up before. And again, we're going to go back over his testimony here on this channel on a live one of these days coming up, probably this week real soon. Partial corroboration. Mr. Kohberger intends to offer testimony of Cy CSLI expert. Mr. Kohberger intends to offer testimony of Cy to show that Bryan Kohberger's mobile device was south of Pullman, Washington, and west of Moscow, Idaho on November 13th of 2022. That Bryan Kohberger's mobile device did not travel east on the Moscow-Pullman highway in the early morning hours of November 13th, and thus could not be the vehicle captured on video along the Moscow-Pullman highway near Floyd's cannabis shop. Not only do we have this in a document, but Ann Taylor stood up in court and said this herself. Additional information as to Mr. Kohberger's whereabouts as the early morning hours progressed, including additional analysis by Mr. Ray, will be provided once the state provides discovery requested and now subject to an upcoming motion to compel. If not disclosed, Mr. Ray's testimony will also reveal that critical exculpatory evidence further corroborating Mr. Kohberger's alibi was either not preserved or has been withheld. That's the exact same thing he's saying again a whole year later. I think that pretty much wraps all of this up. It's going to be an interesting motion hearing on April the 9th, especially since right now, Cy and the other location expert that's working for the defense team are basically just going to be on standby on a Zoom link because the judge is like, oh, they can just put in their declarations. We don't need to have them testify. We shall see what happens. This is damning information, but then again, not new information for those of us with brains that actually follow along to facts. But that is it. Let me know how you guys are feeling about all of this down in the comments. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out. Subscribe to the channel if you are not subscribed already. And please don't forget to make sure that that notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.